This podcast is published solely based off the interests of Jacko Law Group, P.C., and in no way be construed as legal advice. The opinions shared reflect those of the authors and not necessarily the views of Jacko Law Group, P.C. For more specific information or recent industry developments or situations, you should seek legal opinion or counsel. You are hereby notified that any review, dissemination, or copying of this message and its attachments, if any, is strictly prohibited. These materials may be considered attorney advertising in some jurisdictions.
Welcome to Jacko Law Group's Regulatory Compliance and Corporate Law Podcast. I'm Jeremiah Baba Pagano, attorney at the Jacko Law Group. Today, this podcast is going to help us break down the complex regulatory, compliance, securities, and corporate law topics for business owners and professionals just like you. Even the smart and savvy business professionals can be thrown off by legal terms and jargon they may not be familiar with. Our team at Jacko Law Group is here to simplify things. Today, I want to continue the discussion of the first steps of mergers and acquisitions. If you caught our first podcast, you heard about the need to establish goals. So you're here and you may be ready to merge or acquire another business, or perhaps another company has approached you to acquire yours. The biggest step in starting an M&A transaction is the term sheet between both parties. This process is designed to accelerate progress towards a deal or abandon it altogether. It's a step that can't be taken lightly. Term sheets include various items such as non-disclosure or confidentiality obligations, both of which can allow for an open discussion and exchange of confidential information while also maintaining the necessary protections against improper use or disclosure by the party receiving it. When you reach this stage, you can benefit from the experienced legal counsel such as Jacko Law Group, which can ensure that the language in your term sheet is expressly suitable for your transaction, not just a generic or standard term sheet that can omit certain terms and leave you vulnerable. Subsequently, performing due diligence can provide both the buyer and seller assurances that they're making the right deal, and provide them with the necessary information for either party to feel confident or inquire about certain details that may impact the proposed transaction. The eventual effectiveness of conducting due diligence is determined by questions asked and the answers provided. While every M&A transaction has its own unique set of circumstances, here are a few points that should be considered when you're involved in an M&A transaction. Strategic fit. What type of synergies will be created by this particular M&A transaction? Financials. Specific questions must be posed on everything from a company's debt and profitability to review of their audited financials and all future projections. What about compliance? How has the company fared with upholding the compliance obligations? Information technology. Are the current systems compatible and cost-effective with the business you may be acquiring? Workforce. Will there be a need for a reduction in the team, or will you be assuming the employment contracts in place for all the current team members? What about the client base? What's the retention rate? Are there any existing or unresolved issues or complaints that have been brought by clients that you need to be aware of? How about marketing? What does the company do to grow its client and overall business operations? If you are moving towards an M&A transaction, this is undoubtedly an exciting time. But watch out for these hidden vulnerabilities. To find out more and to speak with our team, we invite you to contact us at 619-298-2880 or find us online at jackolg.com. Thank you for listening. We hope you have a great day.